Hello and welcome. This is Emotional Support Animals, and my name is Kara Birdfear. I'm here from the Civil Rights Department, where I'm a senior counsel in the Outreach and Education Unit. Before we get started, I'm just going to give you what I like to call my boring lawyerly disclaimer. So we're giving you this information just for informational purposes. We're not giving you legal advice. We're not giving you policy. We're giving you this information based on what's most recent as of today, but the law is always changing, so keep that in mind if you decide to rely on this information. All right, let's go through our agenda. First, I'm going to talk very briefly about what we do at the Civil Rights Department. Then I'm going to give you a little legal background on the laws that form the protections that we're going to be talking about today. Then I'm going to talk about emotional support animals, which will take up most of our time. And I'm going to end with a brief bit of information on service animals. Okay, here's a little bit about us at the Civil Rights Department. We are a state agency and we have a gigantic job to protect the people of California from unlawful discrimination in housing and employment, from businesses. We also enforce laws that prohibit hate violence and human trafficking. And here are some of the activities that CRD takes on when enforcing the laws with the protections I just spoke about. We, I think, are mainly known for being the state agency where you can file complaints of discrimination when you think that you've been subject to discrimination in employment or housing. So we take complaints and we investigate those complaints. We try and get everyone together to come to a resolution, and we do a lot of that when it comes to the complaints that we receive. We also sometimes go to court to prosecute violations of the laws that we are charged with enforcing. We also do outreach and education, and we do community dispute resolution, and a whole lot more. If you or someone you know is a person with a disability and needs a reasonable accommodation in order to access our services, here's some information on how to request an accommodation. Similarly, if you or someone you know needs our services in other languages, this is how you can go about requesting translation. Okay, let's talk a bit about the laws that we enforce at CRD that protect people from discrimination in housing. The main one that forms the basis of a lot of the protections that I'm going to talk about today is the Fair Employment and Housing Act. This is a California law that protects people from discrimination in housing and harassment in housing based on protected characteristics. We also at CRD enforce the Unrest Civil Rights Act, which protects people from discrimination by businesses, and this includes housing. CRD also enforces the Disabled Persons Act, which gives people with disabilities the same right to public places and public accommodations as everyone else in California. And finally, CRD enforces what we call Government Code 11135. It doesn't have a fun name, unfortunately. And this law protects people from discrimination and harassment by any program that's funded by the state of California. This includes programs or activities that the state of California funds in local governments and cities and counties, but other programs and activities as well. So we talked about the protections that prohibit housing discrimination based on protected characteristics. Here is a list of all of the protected characteristics in California when it comes to housing discrimination. I will note that there is a law called the Fair Housing Act that applies to the entire country, and this law has some of these protected characteristics included within it. So for example, if you discriminate against somebody based on their race, that would be illegal in the entire United States. But California also has additional protected characteristics, and I'm going to highlight a few. So in California, it's unlawful to discriminate against somebody based on their sexual orientation, their gender identity, their gender expression, their source of income, so how they choose to pay their rent, for example, with a Section 8 voucher. Also based on somebody's primary language, their citizenship, or their immigration status. And these protections apply if somebody actually has a protected characteristic. So, for example, they are a person with a disability, then they would be protected by the laws that protect you from disability discrimination in housing. Then you also would receive these protections if somebody thinks you have a protected characteristic and you don't. For example, we recently had a case where a landlord assumed that a family was undocumented and they weren't, and the family was still protected by the law. And these protected characteristic protections apply also when you're associated with somebody that has one of these characteristics. So, for example, a parent of a child with a disability would be protected from housing discrimination based on their association with their child. We also have what I like to call rights that flow from protected characteristics. These include protections such as the right to operate a licensed childcare in a provider's home. There's also specific protections for people with criminal histories, just to name a few. Okay, so now we're going to talk about the laws as they relate to emotional support animals. These protections that I'm going to talk about today come from the law that protects people with disabilities from discrimination in housing. The refusal to give somebody a reasonable accommodation is considered to be housing discrimination. And what I mean by a reasonable accommodation is just a change in rules or policies by a housing provider to allow someone with a disability the equal opportunity and access to enjoy housing. And a reasonable accommodation includes many things. One example, which is very relevant to our discussion today, is getting an exception to a no pets policy for an emotional support animal. Okay, let's do our first poll. Obviously, this isn't live, but feel free to play along from home, and you can just think about what your answer would be, and I'll give you a few seconds to think of that before I give you the answer. So, the first question, what is an emotional support animal? Is it A, any pet, B, a trained animal that performs tasks to help someone with a disability, for example, a guide dog for someone that is blind, or C, an animal without specific training that provides emotional support to a person with a disability? So I'll give you a few seconds. And the answer is C, an animal without specific training that provides emotional support to a person with a disability. So let's talk more about emotional support animals. As I said, it's an animal that provides emotional, cognitive, or similar support to someone with a disability to assist them in managing the symptoms of their disability. Emotional support animals, or ESAs, which I may refer to them in this presentation, are also referred to as comfort animals or support animals. One thing to note, an ESA or emotional support animal, it's not a pet and it's not a service animal. And I'm going to talk about what a service animal is in a little while. My tenants are constantly lying that their pet is an emotional support animal to get around our no pets policy. Did you hear about the person who sued her landlord because she wouldn't let her have an emotional support horse in her apartment? My cousin's friend was bitten by her neighbor's dog, but the landlord couldn't do anything about it because the dog was an emotional support animal. So you may have heard people talk about similar scenarios or have similar opinions or thoughts when referring to emotional support animals. And one of my hopes for this presentation is that we can dispel some of these myths. I know there are exceptions to every situation, but for the most part, many of the things that people hear about or talk about when it comes to emotional support animals may or may not be true. So keep this in mind as we go through our presentation. So why do people have emotional support animals? I think this is an important consideration when talking about the rights and responsibilities with regard to people with disabilities who have emotional support animals. One thing to note is that emotional support animals have been shown to help people with disabilities. There was a recent study where they took a bunch of people and gave them emotional support animals for a specific time period, and they found that there was a significant decrease in participants' depression, anxiety, and loneliness when they were given access to an emotional support animal. Another study found that 2 out of 5 pet owners, or about 42% of those surveyed, had turned to emotional support animals because they couldn't afford therapy or mental health care. So people are using emotional support animals to help manage the symptoms of things like anxiety, depression, and other mental health conditions. Participants in the same study reported that emotional support animals help them with anxiety, depression, loneliness, help them keep a structure and a routine, help them with stress, trauma, gave them sensory support, help them deal with job loss or economic uncertainty, and many other things. So now that we've talked about what an emotional support animal is, and why some people may have emotional support animals, let's talk about rights and responsibilities. So, can housing providers prohibit a tenant or resident from having an emotional support animal? So, on one hand, housing providers are definitely allowed to have rules regarding pets or animals that are living in the housing that they're renting. This can include completely prohibiting pets, prohibiting certain types of pets, certain breeds, certain type of animals. They could also have rules around things like noise or picking up waste. But on the other hand, if a tenant or resident has a disability related need for an emotional support animal, the housing provider must allow the person to have the animal as a reasonable accommodation unless the housing provider can show that an exception applies. All right, here's our next question. True or false? Documentation of the need for an emotional support animal must come from a licensed medical professional. So I'll give you a few seconds to answer. All right, and let's see our answer. The answer is false. So let's talk about it. Okay, so let's talk about the law when it comes to asking for documentation of somebody's need for an emotional support animal. So housing providers can ask for documentation of someone's need for an emotional support animal unless the disability is obvious or readily apparent. So what I mean by this is if somebody is using a wheelchair or has an otherwise very visible or obvious disability, the housing provider shouldn't be asking for documentation of that disability. But if it's not obvious, then the housing provider can ask for documentation. But there are some limitations to what can be asked and requested. So the tenant or resident is not required to disclose their disability. They're not required to give any type of medical records. Instead, the person with a disability is only required to provide documentation that discloses enough information to document their disability-related need for an emotional support animal. And documentation of somebody's need for an emotional support animal can come from One, the person that's making the request themselves. They're often the person that knows most why an emotional support animal is necessary, and documentation could be something like a statement of benefits for a disability. Documentation of the need for an emotional support animal can also come from any reliable third party who's in a position to know about somebody's disability related need for an ESA. And this can be a doctor or other healthcare provider, a therapist, a social worker. I will say in my practice, doctors are often not the right person to provide this documentation, especially when it comes to an emotional support animal, because they're not seeing this person regularly like a therapist or a social worker might. And a therapist and a social worker is more likely to have information about the impact of an ESA in someone's day-to-day life. Others that can provide documentation could be a non-medical service provider, a member of a peer support group, a parent, a child, another relative, or a caregiver. The law does say that this third party must be reliable, which means that people can look into things like how much this person interacts with the person with a disability and how familiar they are with this person and their need for an emotional support animal. Let's do another question. This is a hypothetical involving someone named Hannah. Hannah applies for a vacancy with landlord Carol and notifies Carol that she will be bringing an emotional support animal. Landlord Carol understands that emotional support animals aren't the same as pets, but she wants proof that Hannah's dog is a real emotional support animal. Landlord Carol tells tenant Hannah that she needs a certificate or registration for Hannah's ESA before she can have it in the apartment. Can landlord Carol do this? So I'll give you a few seconds to think about what your answer might be. And the answer is no. So let's talk about it. So does an emotional support animal have to be registered to qualify for reasonable accommodation? And the answer is no. There is no legal requirement that an animal be registered or certified in order for it to serve as an emotional support animal. And businesses that claim to register or certify emotional support animals are often charging for a service that's unnecessary to establish the need for reasonable accommodation. They're preying upon people with disabilities, and there is, again, no registry or certification for emotional support animals. Okay, so I already talked a bit about online services that say that they will register or document your need for an emotional support animal. So, do these certifications, ID cards, tags, or vests worn by an animal establish that somebody has a disability related need for an emotional support animal? And the answer is generally no. A vest or tag worn by an animal that identifies an animal to be an ESA does not by itself reliably establish either a disability or the need for an accommodation. However, there are some legitimate professionals who deliver services over the internet, but this documentation of the need for an emotional support animal must be based on an individualized assessment, which means that they must interact with the person with disability and ascertain what the need is for the emotional support animal, such as why the emotional support animal will help someone manage the symptoms of their disability. So let's talk about when a housing provider can legally deny a request for an emotional support animal. So after a tenant has made a request and, if necessary, shown documentation of their need for an emotional support animal, the housing provider can still deny the request, but only under some limited circumstances. So one, if having the emotional support animal would cause the housing provider what the law calls an undue financial and administrative burden. What this means is allowing that animal would cause the housing provider so much of a cost that it just wouldn't work for them. They couldn't afford it, it would just be impossible. Or they're really asking for an emotional support animal would make it so difficult to manage that person's housing business that it just wouldn't be possible. It's very unlikely that adding an emotional support animal would be an undue financial or administrative burden, but if the housing provider can show that is the case, then they could deny the request for an ESA. The second reason is if allowing the emotional support animal would be what the law calls a fundamental alteration to their business. Usually, fundamental alterations are when tenants make requests that are just very much outside of what a landlord would normally provide or do for their tenants. An example I like to use is I had a client many years ago who wanted to request that her landlord do her grocery shopping, and I had to explain to her that that is not a legitimate request for a reasonable accommodation because most landlords do not do someone's grocery shopping. However, when it comes to things like allowing an emotional support animal to live in an apartment, it's very likely that this is square within what a housing provider would normally do or provide. It involves something living in the home of a place that is rented, so it's unlikely that a housing provider could show that it's a fundamental alteration, but if they can, again, they could deny the emotional support animal request. And the third is if the animal and having the animal constitutes a direct threat to the health or safety of other people or property. And also if this threat can't be reduced or eliminated by additional accommodations. And we'll get more into what I mean by that in the next slides. Can someone have more than one emotional support animal? The answer is yes. If the need for multiple emotional support animals is not obvious or readily apparent, the housing provider can request documentation verifying the need for multiple animals. So they can ask for documentation on why, two cats instead of one is necessary, for example. But the housing provider can consider whether the total impact of multiple animals in a housing unit could be, what I talked about as an undue burden or a fundamental alteration, because maybe I had a client, for example, who wanted to have 6 chickens in his apartment, and the housing provider said no, that it would just not be possible, that it would not only be a possible damage to that apartment, but the noise and everything along with it would likely disturb other tenants. And, allowing somebody to have 6 chickens in their home as opposed to a domesticated cat or dog or other animal, is really outside of what many housing providers do for their tenants. So under those circumstances, an ESA may be denied because housing providers can have reasonable rules. What about charging a fee or rent to have an ESA? So some housing providers require a charge in addition to the tenant's rent. They call it pet rent sometimes, or they make you pay an additional deposit or additional funds. Can this happen for an emotional support animal? And the answer is no. So housing providers can't charge someone with an ESA a pet deposit or pet rent. And this is true even if they charge tenants for other additional fees. This is because an emotional support animal is considered to be not a pet, but a necessary assistance to somebody managing the symptoms of their disability. It sounds weird, but you could say, an emotional support animal is like a medical device. So housing providers should be allowing that and not requiring somebody to pay additional funds to have medical assistance. Also, housing providers cannot require someone with an emotional support animal to get liability insurance in the case that the animal causes damage or does something or harms someone else. They cannot require that. However, the tenant could be held liable for any damage that the animal does. That could be taken out of their security deposit. If an animal does things beyond normal wear and tear, for example, the housing provider can collect funds from that and ask the tenant to pay for those repairs. So let's do another question. This is a hypothetical also involving landlord Carol. And now that landlord Carol understands more about emotional support animals, she decides to rewrite her lease to clarify her emotional support animal policies. She makes it clear that emotional support animals are allowed, but she specifies that only small dogs and cats are allowed, and that absolutely no quote-unquote bully breeds, like pit bulls, are allowed because she considers them to be unsafe. So do you think landlord Carol can do this? I'm going to give you a few seconds to think about it. And the answer is no. So restrictions on breed, size, or weight of emotional support animals are prohibited. This includes these restrictions that some homeowners insurance companies have, where they'll say, they won't let somebody rent to somebody who has like a pit bull or a German shepherd or other types of animals that have a stereotype of being violent or destructive. And this is because the determination of whether an animal poses a threat to health or safety or property has to be done on a case-by-case basis. So it has to be based on that particular animal that the person is requesting as an emotional support animal. It can't be based on stereotypes. So, for example, I like to tell people that the only time I was ever bitten by a dog was many years ago, but it was from a Chihuahua, which a teeny tiny dog. I've never been bitten by a large dog or any of the animals that are stereotyped to be violent or to cause a lot of damage. And this is just to say that, every animal is different. The temperament and personality of every animal is different, and housing providers need to assess that animal on a case by case basis. So, for example, a policy banning tenants from having pit bulls would be unlawful, but if that particular pit bull regularly growled or tried to bite other tenants on the property, and the risk of the dog biting someone, couldn't be reduced by another change or a reasonable accommodation, that housing provider could, under those circumstances, say no, you can't have that dog as an ESA. Or we were talking about those myths and stereotypes. So somebody was saying, a dog was biting their cousin's friend's neighbor, and they couldn't get um, rid of the dog. The landlord couldn't do anything to deal with the situation because the dog was an emotional support animal. That is simply not true. A housing provider can ask that an emotional support animal leave a housing situation if the animal can be violent, that particular animal, or can be shown to cause significant damage to property. What kind of rules can housing providers impose on emotional support animals? So as I said, housing providers can have reasonable rules. Housing providers can have rules for things like, picking up the waste of an animal or not letting the animal be a nuisance to other people. Maybe the animal barks constantly and is just causing a lot of noise for the other tenants. There could be a rule prohibiting that. This is okay as long as these rules don't interfere with the performance of the animal's duties. So, for example, if the animal needs to be off leash to provide certain types of support to that person with a disability, the rule can't be that they always have to be on leash. But there could be a rule that says that the animal has to be in control of the person with the animal at all times. So this means as long as the animal is off leash, it's fine, but if it's jumping up or approaching other people or just not under the control of that person, that would be another story. But having rules that interfere with how the animal supports somebody with a disability are not allowed. Also, any rules put on emotional support animals cannot be more restrictive, or they can't be different from rules for other animals on the property. So, for example, if a housing provider has a pet policy where they allow people who have dogs 25 pounds or less on the property, and somebody requests exception to that rule, saying, that they have a dog, but the dog is 60 pounds, the housing provider can't impose more strict rules for that larger dog. They have to treat emotional support animals like any other pets. So they have to be consistent rules for everybody. So there was a law that was passed a few years ago in 2021. It was Assembly Bill 468. And it's been causing some confusion for folks, so I want to talk about it. So in 2021, California enacted a law which, among other things, requires businesses that are selling emotional support and animals or things like those vests or tags or certifications to notify the person that an ESA is not specifically trained to be a service dog and is not entitled to the rights of a service dog. It also places some conditions on healthcare, but I'm going to get rid of this. So now let's talk about service animals and why they are different than emotional support animals. So service animals are animals that are trained to perform specific tasks to assist people with disabilities, including people with mental health disabilities. In contrast, as we discussed, emotional support animals are not service animals and are not specifically trained to do a specific task, but they provide emotional support to someone with a disability. Service animals that are trained to do specific tasks do not have to be trained by a professional trainer. They don't have to be certified. They can be trained by the person with the disability themselves or another person. Another thing to note is the same as emotional support animals, service animals are not pets. And some examples of service animals, so a guide dog for someone who's blind. There are also animals that are trained to sense when someone's having a seizure. My daughter was in a preschool where her teacher had a condition where he had seizures and he had a dog that came with him to work, and that dog was able to tell before he was going to have a seizure, and the dog would alert him so he could sit down. So those are examples of service animals. So in contrast to emotional support animals where there is a reasonable accommodations process, asking to have a service animal in your home is not a reasonable accommodation. You have a right under the Americans with Disabilities Act and other laws to have a service animal in your home, and a housing provider can only ask 2 questions to determine if an animal is a service animal. So the first question is just asking somebody if they have a disability, and the second question is, what is the disability-related task that your animal has been trained to perform? And that's it. They can't ask the person to have their animal perform that task in front of them. They can't ask for additional documentation. Those are the only 2 questions. And this is just for service animals. So we've reached the end of our presentation, and I just wanted to share some resources which you can get to by scanning the QR code on the right of the slide. These are resources specific to emotional support animals and disability discrimination. I also want to let you know that we are doing 3 webinars a month. These are live webinars where you can ask questions and there's more engagement because you're able to make comments and ask questions live. And you can register for any of these webinars. They're completely free of charge. So here's the information for registering and getting more information on the topics that we are providing webinars on. Also, as you may note because you are here, we have additional free on-demand trainings on our YouTube channel. And I just want to thank you for having my attention and letting me talk to you about emotional support animals. And we encourage you to check out our website. And if you or someone you know believes you've been subject to housing discrimination, you can file a complaint, and here's information on how you can do that. And thank you so much for your time. Take care.